This new reporting from the New York Times is at least one indication why the president is a hard no on handing over any of his recent taxes. He does not like the story it is going to tell. At the same time, House Ways and Means Chairman Richard Neal has a job to do and is meeting with counsel to weigh the next steps in this fight to do oversight, which includes the taxes. A member of this committee wants to get tough with the president. He is Democrat Lloyd Doggett, here to make his case. Welcome to the show, sir.
Thank you, Chris.
First, the New York Times. What's your takeaway?
It's shocking. You know, the president's demonstrated that he's a loser, and not just any loser. He's the biggest loser as far as individual taxpayers in that period of anybody in America, knocking out the competition in some years almost 2-to-1. It does raise another question as well. How does someone who is such a big loser eventually get bailed out by a foreign bank? What other kind of money from abroad was floating in to keep him afloat? So there are many questions out there. These were older tax returns. It certainly demonstrates another reason why we need the more recent returns.
Well, now, obviously, in the 2000s, he got the gift of that reality show, and in fairness to him, he wound up doing it the right way, became a big hit, and he got tons of cash flow, which I'm sure helped him. And at some point, we're going to know that story, especially if you guys do your job and win in court.
Indeed.
Now, why do you think you'll win in court? The fight is pretty simple. The statute is very clear, but it's never been used this way, so it's untested. They'll say it's not real oversight. This is a political attack. You have no reason to get the taxes. You could just call the IRS and say, did you audit the guy or not? You don't need the taxes.
Well, we do need to know how this audit function operated. We have the history of President Richard Nixon, who was actually praised by the Internal Revenue Service publicly. But when we really got into a chance, our predecessors on the committee at that time, to look at his returns, it turned out he owed a significant amount of money in unpaid taxes. This statute, as you know, almost 100 years old, could not be clearer. Shall means shall, and you don't need a law firm, a stack of lawyers, including his new personal attorney, Bob Barr, to advise about these things. The statute is clear. I think that Chairman Neal can either seek to enforce the statute without a subpoena, use a subpoena, or we have the possibility of holding the secretary or the IRS commissioner in contempt.
Now, you are one of the few Democrats who's not just saying, hey, it's wrong for the Republicans or the White House to stymie our oversight. You're on the Democrats as well. You believe they're playing too passive. What do you want to see?
Well, I think that we're informed now by the president's new policy of obstruction today, obstruction yesterday, obstruction forever. He doesn't want anyone to talk. He doesn't want any documents produced. He creates a void with secrecy that he fills with more and more lies. And so what I want is for us to recognize that we're under new conditions. This is not a time for timidity. We need to be forceful. We need to use every tool. He seems to be almost begging for impeachment. I don't think it's time to go there at this point. But I do think it's important to use all of our powers, one of which is the inherent power of contempt.
All right. Oh, yeah. Inherent contempt, which is what?
What it means, and recognized by the United States Supreme Court in the 19th century, is that the Congress can, on its own part, issue a subpoena and enforce that subpoena through arrest or through fines. And I think we need to be prepared to do both.
You don't want to throw the AG in cuffs, though, right? I mean, you know that would cause rancor and division that we certainly would have a hard time bearing in this current climate.
All I want is for the Attorney General to realize he has a responsibility to the public, not just as a personal attorney of Mr. Trump, and to comply with the law. So if we have a lawless Attorney General or a lawless Secretary of the Treasury or some other official, it is our responsibility as a co-equal branch of government to hold them accountable. Now, I don't want to throw him in jail, but I'm ready to do so.
I hear you on that, Congressman. You know, look, I'm of two minds on this. I've changed what I've been arguing in the closing argument about this. Originally, I was like, I just don't see the percentage for you guys. I don't see where it gets you as Democrats. But I now understand that there's a difference between overreach and oversight. But this is a question that many are concerned about in this country. Look at these poll numbers that we have here about how people feel on this. The idea of how much is too much. 44% already says that you're pushing too much on investigating the president. Right amount versus too little, you know, it'll get you to 53%. So you're 53-44 if you want to look at it that way. I guess you could even argue I laid those stats out a little deceptively to weight them against you. But putting that aside, are you worried that it's going to be too much?
I think this is part of President Trump's overall strategy. By building a huge stone wall, by denying anything, any reaching out we do to get the truth is viewed as an overreach and is promoted by him as an overreach.
Well, that's what Pelosi said, right? Pelosi said today that she believes that the president is goading, G-O-A-D-I-N-G, pushing you guys, taunting you to impeach him. You believe that?
I think he is. We see impeachment mentioned by all of his supporters, his enablers here in Congress, as well as by him. That doesn't mean we shouldn't consider doing that if there are no other alternatives. But I think this inherent power of contempt, which would involve perhaps our contracting with the jail, perhaps adding some security personnel to do an arrest, not because we want to arrest or to jail someone, but because we realize we have to show we're serious about this. We're not just going to go on through the courts and let them run out the clock. Chris, you know, as a lawyer yourself, I served for a time as a Texas Supreme Court justice.
Yes, sir. I'm aware.
The appellate process can go on and on and on with hearings and briefing schedules and rehearings. We can't let this administration run out the clock on the truth. The American people need to know that. And also, from my background as a judge, I'm very concerned not just about this president, but about precedent. The precedent we are saying for another power-hungry president who would reach out and grab for more. President Trump, when he makes these outrageous maneuvers, when he offers his bigoted statements, and Republicans are silent and Democrats are timid, he's encouraged to grab for a little more. And I'm concerned about the erosion of our democracy by his conduct.
Well, look, it is interesting. I mean, you know, that you see the timidity of your own side as a factor in this. It'll be interesting to see what kind of adjustment there is. Let me ask you about a little look into our potential future. Investigating the investigators. We both know that IG reports, Inspector General reports rarely come back showing nothing of any suspicion on what they've been looking at. There may be no referral, certainly for criminal prosecution or follow-up, but the idea that they'll have nothing to work on about the surveillance process that took place during that 2016. I think you'd agree with me, Congressman, certainly understanding the process as a former judge on the state level. There's a good chance they'll have something. Now, Christopher Wray today, do we have sound of it, Mel? All right, so Christopher Wray today said in the Senate hearing, he has no proof that there was spying done in response, I believe, to Jeanne Shaheen. What does that mean to you in terms of what we need to look at going forward?
Well, it means that Bob Barr used the term spying because it's a loaded term for what appeared to be a court-approved investigation that was underway and did not involve spying. But do
you believe it was only based on the dossier, information that was bought by Clinton from the Russians, fruit of the poisonous tree?
No, I don't, but I believe that we should see the Inspector General's report before making a final decision, and I don't think there's justification for launching a big, new, distracting investigation when we have the facts right now and the president trying to stop Bob Mueller from coming here to explain them.
Do you think he can do that?
Well, I think he can. I don't think he'll be partisan in any way. I think that everything the Judiciary Committee or the Intelligence Committee does with him needs to be centered on the law and his responsibilities.
Understood, but do you think the president will block him? As long as he's working for the DOJ, he's working for Bill Barr, Bill Barr could say no.
Well, he could, and he would be reversing himself as he has reversed himself and as the president does.
He said he had no objection. But what if the president has an objection? And he then says, well, the president doesn't want him to do it, so he's not going to do it.
Yes, and that's entirely possible. But of course, I don't think that Mr. Mueller will be forever a Justice Department employee. And I would hope when he completes his responsibilities, which should be soon, that if he's blocked by the president and his hand-picked lawyer, Mr. Barr, that Mr. Mueller will then be able to testify before our committees.
Congressman, thank you so much for weighing in on these matters of great importance in a time-sensitive way. Thank you very much.
Chris.
Lloyd Doggett, Texas, Democrat. Thank you, sir.